All right. Hello, everybody. I'm just going to do a little sound check just to make sure that our attendees can hear me. So if anybody can chat, maybe in the Q&A side, just say, yes, you can hear us. That would be great. Uh-oh. I don't see anybody. Do you guys see anybody?
Nope, but I can hear you.
And I can hear you. Yes, there we go.
Thank you,
we have
Debbie.
A yes.
Debbie wins the prize. She gets all right. Well, we want to go ahead and get started because we know that everybody has been waiting for this great quarterly event. This is our second Reish brief. And by way of introduction, my name is Janya Stout. I'm a senior consultant as well as the president of Prime Capital Retirement and Financial Wellness. I am super excited to introduce both Fred and Nevin today. A little bit of background about Nevin. I've known Nevin, gosh, since back in your plan sponsor years, Nevin. I was a little girl, as I like to think of myself, but Nevin was the global editor-in-chief for almost 13 years at Plan Sponsor magazine, or Plan Sponsor. So if any of you attending read Plan Sponsor magazine, I think nowadays it's mostly online, but there's also a conference they do. And then he joined American Retirement Association as the chief content officer. And I followed him through. I first met Nevin at Plan Sponsor. And then those who may know me, I'm a past president of NAPA, which is National Association of Plan Advisors, which is under the umbrella of American Retirement Association. And then last year I was voted onto the board of American Retirement Association. So I've known Nevin for many, many decades. He is a thought leader in everything about retirement. Just a little plug, if you don't follow him on LinkedIn, you should. He does video updates and is probably one of the best writers. And I love reading everything that he writes about. But he spent almost 9 years at American Retirement, and then he, air quote, retired. Even though I tease him, he hasn't done much about retiring because I think he's still pretty involved. So Nevin's our guest today. And then Fred Reish, I feel like Fred is somebody that, how do you even introduce Fred? He's probably the most well-known ERISA attorney. I was teasing him earlier. His LinkedIn profile doesn't actually say much other than he's been an attorney for a long time. But the exciting thing is he joined Prime Capital in January of this year. Never in my million years dreams did I think that I would be actually working with Fred, even though I've worked alongside of him for decades as well. So I am going to really just be a commentator on different topics, but I'm going to hand it over to you, Fred.
Hey, thanks, Janya. And hello, everybody. This is Fred Reish. And two things before we get going very quickly. One, Nevin is also a lawyer. So you've got me as a lawyer and Nevin as a lawyer. Obviously, we're going to talk about litigation and about really about what plan sponsors should learn from it, good and bad. Number two is that Nevin and I do a podcast separate from all this called Nevin and Fred. Now, we're not particularly original in naming things, but
guess who came up with that name, by the way?
I don't know. Did we hire a consultant? But if you go to Nevin and Fred, one word, just all spelled out, nevinandfred.com, you can sign up there and get our roughly monthly podcasts on all things ERISA, but particularly ERISA litigation, which is something that Nevin writes about a bunch. So Nevin, those are my two introductory things. Nevin and I are old friends. We hang out together. We have fun together.
Yep.
We hope you have fun today with us as we talk about ERISA litigation. But Nevin, we talked about this earlier, and we thought, most programs where they talk about ERISA litigation, they almost are designed to scare the daylights out of plan sponsors. So they start off with a parade of horrors. And I thought we'd do something different. You liked the idea. So we decided we'd start off with a good case, something positive, but still that folks can learn from. So Nevin, the ball is in your court. What case did you pick, and what do you have to say about it?
Well, first off, and thanks for letting me come and hang out with you guys. It's fun to do that. Like Fred said, he and I hang out a fair amount anyway, and that's always kind of fun. And it's really cool to see Janya again. So thank you. It's really hard to say what's your favorite ERISA litigation case, because the truth of the matter is my favorite ERISA litigation case is the one that never happens, that doesn't end up sort of dragging a poor plan sponsor into court to defend what in a lot of cases is they didn't do anything wrong at all. And I think, just as acknowledgement there, certainly during the COVID era, believe it or not, litigation in ERISA really picked up. And, the saving grace on some of that is if you're not a very large plan, you're probably not going to find yourself in a litigation situation, because people understand how class action collections work for the plaintiff's bar, and they're going to go where the money is, the old Willie Sutton kind of thing. So that's kind of the issue. But to Fred's point, I've always been really interested in the notion of ERISA litigation, because I think that you can learn things from the lawsuits themselves. And the caveat on all this, and when I write about when a lawsuit is filed, I end up always putting the caveat that basically says, look, this is one side of the story. And it's one side of the story that might very well be biased, or certainly seen from a single perspective, and doesn't necessarily catch the whole idea. Because what we have seen as these cases go to trial is that the people who are bringing suit, they don't always, A, they don't understand ERISA, B, they don't seem to know how to actually calculate the fees when they're alleging excessive fees. And based on a couple of these cases, they don't even know how to measure performance properly. Unfortunately, you have to go to court sometimes to sort of get through that. But the cases that I sort of want to bring up, at least at this juncture here, is a reminder that actually could apply to plan sponsors of any size. And these are cases, and there's 3 of them fairly recently, and I'll just sort of deal with them as a grouping. And they have to do with claims about beneficiaries, because you don't have to be a big plan to have a participant in your plan who dies, sometimes untimely, and is not necessarily done all they should do to make sure that their beneficiary designations are up to date. This happens a lot when people either get married later on, or they get married and they get divorced later on, and you end up with some fairly weird and situations. One of the cases, the participant had actually filed in to do a change of beneficiary, but the instructions on the beneficiary form required that the beneficiary be provided in whole percentages. As you might imagine, they were doing it among 3 individuals, and they put in 33 and a third for each of the individuals. And then, believe it or not, it got rejected because they didn't follow the instructions. The instructions call for it to be whole percentages, so they should have rounded one of them up to 34, but presumably didn't want to do that. And believe it or not, in this case, went through a district court and then got appealed, and the court ended up saying you didn't follow the instructions, therefore your change of beneficiary designations didn't take effect. And so it's just a reminder of how important those kind of things are and that level of detail. And again, this is a situation where they were very specific in their beneficiary designation change instructions. So sometimes I think you want to be aware to leave a little more wiggle room for that. We had another one where, yeah, you going to say something, Fred?
Yeah, I was just going to say, I I don't think people realize how often these issues come up of designations of beneficiary. And just two quick stories before you go to the second case. The very first case I ever had as an expert witness was a designation of beneficiary case. The owner of a company that sponsored a retirement plan died, and they found the designation of beneficiary in his home office. The plan document said the beneficiary designation has to be filed with the company. What I testified to, and the court upheld the designation of beneficiary they found in his office at home. What I testified to was that with small business people, they can sort of work any 24 hours a day they want, because when you own a small business, it is a lot of your life. And that from the perspective of the owners of closely held businesses, that home office, I testified, was often considered to be part of the office of the company. And the court agreed with that and validated the designation of beneficiary they found in his home office. Another case, that was a good story. Another case, a bad story, where I had a client that went bankrupt, big, well-known company, went bankrupt. In the process of getting rid of the records, after closing everything down, they found a file cabinet that they couldn't unlock. It was locked. They couldn't find a key for it. So they just gave it away to charity or threw it away. That file cabinet had all of the designations of beneficiary for the whole plan. We're talking a plan that covered like 1,000 employees. You can imagine the disaster that was. And the reason I bring that up is obviously, well, there's a good story about the closely held business, a bad story about that file. But the reason I bring that up, Nevin, is that sometimes I think that businesses may not fully appreciate that they've got a job in processing properly and retaining their records. And I agree with you. The rules shouldn't be so tight that folks can stumble over their own designation of beneficiary. If you have 3 kids and you want to leave a third to each, you ought to be able to. And that was just in my view, that was a mistake to have that as one of the rules. But I do think that folks, it doesn't have to be the plan committees, they can have their benefits people or their HR people look at the rules and what's done. Are they keeping the designations? Where are they keeping them? Because these lawsuits are, one, they're traumatic. I mean, they just take a toll on the people at the company and on the beneficiaries. And number 2, they're expensive because you got to get lawyers. Even if you're the company just saying, hey, we represent the plan. We just hold the money. You court tell us who to pay it to. You're still pretty deeply involved in the lawsuit, and you got to have legal representation. So yeah, that can be a mess. So it's a good point, Nevin, that folks ought to pay more attention to that. So anyway, that's my little frolic and detour on what you were talking about. Go back to where you were.
I will. Before you do, Nevin, I'm just going to chime in, because anytime a plan sponsor, attends one of these, right? Like, our goal is to give you takeaways, not just, let's just talk about the lawsuits. But I think Fred and Nevin bring up a really good point. And Fred, you just mentioned it, making sure that you understand, how you're processing these things and, documenting it as well, especially on beneficiaries with the rise of auto enrollment. It is, I'm seeing more and more issues around, plans having a higher percentage of employees that don't have beneficiaries, because in the old days, you had to enroll yourself, and the record keepers have good processes, that say, like, that take you through that enrollment to designate a beneficiary. Or even going back when I started and things were with paper, we'd hand out beneficiary forms. Now with auto enrollment, there's definitely that step is being missed. So I know here at Prime, we make that a point, as far as locating and making sure what percentage of our plans have, employees that haven't designated. So that would be a good takeaway for you, to make sure that you're talking about this either administratively or at the committee level.
Yeah, just to very quickly add, one more thing. If you don't have a designation of beneficiary for a participant and the participant dies, your plan document says what happens, and the law, like a spouse is favored, obviously. But your plan document will say what happens. And does it go to the estate? Does it go? Your plan document might say it goes to the issue of the decedent per stirpes. What the heck does that mean? Well, it means if you have 3 kids, it goes to them equally. If one's dead, their 1/3 goes to their kids. If they don't have them, then it goes to the 2 kids. I mean, but there are all these rules in your plan document. And so you sort of have to be careful to administer it that way. But anyway, I'm far afield now. Nevin, back to you.
No. You guys are hitting right around the cases I had. They deal with real life situations, are exactly the kind of things we're talking about. I mean, one of them, for instance, and you think about a lot of times these functions, the processing of distribution things have been outsourced to a customer call center. Well, there was a case where somebody tried to change their beneficiary through the call center. They might have very well gotten an affirmation from that call center representative that had taken place. But guess what? It didn't take place. It wasn't effective. And therefore, they thought they had done the right thing, but it doesn't show up anywhere on paper or whatever. They didn't know it hadn't been done properly. And of course, it gets found out after they are no longer with us. And so that, again, is a reminder about the importance of sort of keeping up with that. And then the other thing, and kind of echoing what Jania was talking about and what Fred was talking about, because there was another case where an individual, they had been married, they got divorced, they changed their beneficiary, and they changed it to their children. And that, believe it or not, this is a case where their beneficiaries actually showed up on the participant statement. So that's the good news. It was a way for them to see the statement all the time and know, in fact, that the beneficiary had been changed. Then they got remarried. And what happens then is exactly what Fred talks about, because at that juncture, even if you'd filled out the beneficiary form, because they filled it out before that second marriage, then that second wife ends up being, by law, the default beneficiary. So even though they had changed it properly, even though they were getting statements that continued to show that their children were the beneficiaries, the law stepped in and their second spouse ends up being the designated beneficiary. Now, to Fred's point, that required them going to court to have all of that argument, and that participant's no longer there. And you know what that participant probably intended and thought had been put in place, but actually wasn't. So again, to me, these situations, and they're not the headline cases that we can also talk about, and there are plenty of headline cases, but these are kind of real world. They apply regardless of your plan size, and it's a basic understanding, first of all, to know what your plan requires and to know what the law will impose, even when your plan document might say something different. So it's a key thing. And to Jania's point, automatic enrollment, as wonderful as it has been for so many opportunities, it has made it very easy to be in the plan without a properly updated beneficiary designation. So you want to make sure that you've got in place a process that allows for that to not only be reviewed, but to remind participants at least once a year, just, hey, have you checked your beneficiary designation, and make sure that they have a way to do that. Because otherwise, this is all going on in court, and that participant's not with us anymore to lend any sort of insights. We're dealing with what the law requires and what the paper tells us. So Fred, do you have a favorite?
Well, in terms of I have a favorite favorable case and a favorite unfavorable case. But let's talk favorable. And it's a case you're familiar with too, Nevin. It's the Quest Diagnostics, the big company Quest. They were sued about the quality of their investments. And one of the investments too, specifically. By the way. What's that?
A new case. It's new.
Oh, brand new. Yeah, this is.
Yep.
And the target date funds were part of the claim that the investments underperformed, and the case was decided in favor of Quest, and it went up on appeal, And the appellate court also decided, part of the reason that's one of my favorite cases is that it says, the judge said in the Court of Appeals opinion, ERISA mandates prudence, not perfection. And I think that's a good message for plan sponsors. First, plan sponsors won the case. But secondly, the judge says, hey, you don't have to be perfect. You don't, and there are other parts of the decision that say you don't have to know what's going to happen in the future, because nobody knows if something's going to outperform, underperform, or perform exactly as benchmarked in the future. You just have to have a good process. And Nevin, I think there are more cases coming down. You may have mentioned this earlier, that there are more cases coming down that say, if fiduciaries have a good process, then we, the courts, are going to find that they acted prudently. And of course, when Nevin and I talk about process, we're talking as lawyers. And the word, I'll talk about what process means in again, but from a lawyer's perspective, it means, can you prove that you had a good process? So there's truth and there's proof. Can you prove it? And that means it's great to have stuff in writing. Right. But some of the one reason that the court found that the plan committee had a good process was they had a well-known advisory firm working with them, giving them reports. They actually did remove some investments, just not the ones that were complained about. So it showed that their process wasn't just like there, but it was actually producing stuff. The plaintiff's attorneys argued that the plan committee failed to follow their investment policy statement, which would have been a pretty good argument, although the courts are split on whether or not you have to follow the IPS as if it were a plan document, which you do have to follow. So there's some courts that go one way, other courts that go another. That's a warning. But in this case, the judges said, hey, this investment policy statement has a provision that says that, in effect, the investment policy statement are guidelines, that the plan committee is not required to follow them. So the very investment policy statement itself said, plan committee, you don't have to follow these. This is just to be helpful to you. Now, there's a lot of ways you can word that. I've worked on all kinds of IPSs, and they've been worded different ways. But the point is, you want that kind of a provision. And I think you all do. And my assumption is that everybody that works with Prime has got that kind of a provision in their IPS, because I know the Prime standard IPS, and it's got it. But anyway, Nevin, what did you think about?
Right?
Yeah.
You helped write it, yes.
Yeah.
Well, then, well, the Quest case exactly did that. The judges made a point of saying that the language in the IPS was permissive. It said the committee may remove a fund if certain conditions are. It didn't require them. And that, again, I think sometimes, it's easy to sort of without thinking about the real world, to kind of put in, you're trying to lend clarity. You're trying to create black lines, in the document that give the committee sort of clear ideas about what they have and have not to do. But it ends up creating a problem. It puts you in a corner, if you will, and sort of forces you to do something that might have other factors that are also there to be taken into consideration. So again, you want to be careful about being overly prescriptive in terms of the legal language in the document and that sort of thing. But I'm with you, Fred. I like the Quest thing. I think also one of the things the judge led off with, he says sometimes even a good process produces disappointing results. And I think it's really key there again that, and you see this time and again in cases, there are in recent months, there has been a resurgence. I mean, the market, although it's been volatile, the market's actually been overall pretty good. So you expect to see suits coming to tone to, challenging investment results when the markets are bad. But actually recently, despite the markets being overall good, there's been a lot of suits. And when I say a lot, I mean probably about 20 different suits, although a group of those are all about a single target date fund family. And they're challenging it on performance basis. And traditionally, historically, the courts have not not been, I mean, they give the fiduciaries the benefit of the doubt. They're not expecting 20/20 hindsight. They're allowing for the fact that you might have results that at different points in time might be less than what you might have somewhere else. But the courts really, I think, have overall, as long as you have that process, and to Fred's point, as long as you be able to document that you have, in fact, that process, and that includes things like taking the time and deliberations to engage an advisor to help you make those kind of decisions. Those are all things that the court will look at and basically say, ERISA doesn't require you with 20/20 hindsight to be perfect. It requires that you've got a prudent process in place, something that's keeping in mind the best interest of participants and the beneficiaries, and basically being able to prove it. And that, in all the cases that I've seen so far, has been enough not only for you to win at trial, but for you to win in a situation where you get it, you grant the motion to dismiss because you have that baseline. So Quest is a good case. It's very recent, and it's a reminder of all those good kind of fiduciary 101 things that we tend to talk about.
Yeah, I think, Nevin, to boil it down, sort of what you and I have said, if we wanted to create like a checklist for plan sponsors of all these cases, including Quest, like what did the judges point to as evidence of a prudent process? Meetings, have meetings. That's not, but the most common periods or sequence of meetings is quarterly. You don't have to have them quarterly. There's no rule that says that. But quarterly is so common that if you don't know what else to do it quarterly. So have meetings. Number two, have an investment policy statement. Even though we're pointing out you don't want one that's too restrictive, too many rules, and you want flexibility built into it. Having one is something courts point to as a prudent evidence of a prudent process. Number three, work with an advisor. Court after court, the NYU case, the Quest case, court after court has said, well, yeah, these guys did what they needed to do to engage in a prudent process. Have minutes of committee meetings. They don't have to be real detailed, but they should say who was there, generally what was discussed, what the recommendations of the advisors were, that there was a discussion, there were reports, the reports were reviewed, and then that gets to the next one, which is have reports, have written reports from probably the record keeper and the advisor. And then where, as a practical answer, where something's been underperforming, you don't need to remove it, but probably say why you're not removing it. I read a report years ago, every top mutual fund manager in history, of the top ones, the very best ones, has had at least one period of 3 consecutive years of underperformance. What happens if you got rid of them after 3 years? You missed the rebound. So what we're really talking about with performance is what's the quality of the investment manager. That's what you're really trying to figure out. And 1 or 2 years just means that their strategy is playing out more slowly than they thought it would play out. That's all it means, because they're a great manager. But anyway, those are the ideas. Those are specific items that could be evidence of a prudent process. And Janya, did I miss anything, or did that pretty much capture it?
Oh, I think that was great. I think I think we could have a whole session on committee notes, because that tends to get brought up quite a bit. What should you write in the notes? What shouldn't you? But I don't want to open up that can of worms if we have other cases to talk about.
Well, Nevin.
So go ahead, Fred.
Let me just point out, you talked about the market's been up and usually suits come from underperformance. I want to talk about the BlackRock TDF target date fund suits. There was that period from 2010 roughly to 2020 when the market went up, 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 up. The market only knew how to go up. And plan sponsors, large plan sponsors, household names that had the BlackRock target date funds in their plan got sued because they underperformed. Not because, so the market going up caused those lawsuits because those target date funds were conservatively designed. I think similarly, the Intel lawsuit, although they had a custom target date fund, they included hedge funds and private equity funds to mitigate volatility. In other words, so the values didn't bounce around so much, meaning they were a little bit more conservative than maybe the moderate typical moderate target date fund. So they got sued. So, you know, I mean, the sad message that I'm giving you is if market goes up, conservative investments get sued, even if they're appropriate for those employees. Market goes down, aggressive investments get sued, even if they're appropriate for those employees. That's why this process thing we're talking about is so darn important. But what do you want to add to the target? I mean, the reason target date funds are getting sued is because that's where the money is now. I think like 50% of new money going into plans nowadays is going into target date funds. So I expect to see more of them. Nevin, what do you think?
So are we in the good news or the bad news part? I've
Give
lost
one
track.
of each. Yeah.
Well, yeah, I mean, because again, and what ends up happening in the BlackRock case, to your point, Fred, they had a more conservative glide path. I mean, arguably, if y'all remember all the way back to 2007, 2008, you know, I mean, there was a reason for people to look at that in market environment and say, you know what, target date fund, when you get right close to the target date, you probably shouldn't be fully loaded into, you know, you should be more conservative in terms of how you approach it. And BlackRock did exactly that. There's American Century is another one that had, I believe their glide path was more of a to retirement glide path instead of a through retirement glide path. If you don't know what those differences are, we can talk about them later. But essentially what it meant was they had a more conservative glide path. And guess what? A more conservative asset allocation, a more conservative mix of stocks and bonds is not going to perform as well when the bull market is just running away with things. So if you can get like sued for that, that's where that process really comes in. The Intel case, which you mentioned, Fred, is right now being heard before the United States Supreme Court. And it is an argument about what is, in fact, a meaningful benchmark. And the Intel folks have just filed with the Supreme Court a response to this. They have won their case at every level. They've won at the district, and they've won at the appellate court level, and now it's been appealed up to the Supreme Court. And what they're saying is, specifically in the wake of 2008, 2009, they were concerned about the market volatility. They elected to go with a custom target date strategy that muted that buffered it in. And it did exactly that. It was less volatile. P.S. It also meant when the markets were surging, it was, you know, a smaller return, and they get sued for it. So that's the kind of thing that on the one hand, from my standpoint, is really frustrating, you know, thinking about it from a plan fiduciary standpoint, because and that's why it's so important that even in the Intel case, they've got that documentation. That's why they've won every time it's come up through the courts so far, is because they've been able to point to a specific strategy with a specific goal in mind that in fact their strategy achieved. It's only a shame that they're having to go through all these layers of litigation, proving that time and time again. But the good news is I have every confidence, every reason to think that they will prevail, because they did have that, and because that's consistent with what ERISA requires.
Yeah,
I have a question for you guys on this. Yeah. And we didn't prep for this, everybody, because, you know, hearing the two of you talking about glide path and do you select a more conservative target date fund? What about, you know, and this happened with a client of mine years ago, where the new chair of the committee he was the new CFO of the company, and he was more aggressive than the committee had been before. And he came into the committee and wanted to completely change the philosophy of what the target date funds were going to be. And, you know, again, the best I could do at that time was like documenting that, you know, the committee or that the committee felt like this was now appropriate. But it was a completely different strategy than what we had been doing for years. And I would just ask you, Fred and Nevin, like, what would you suggest doing in that situation? I mean, plan sponsors do have the right to change their mind, right? But like, sure, how do you do it in a way that doesn't make what you were doing look bad?
Well, Well, I know what Fred's going to answer, so I'm going to let Fred answer it because I know what Fred's going to answer. So I'm going to let Fred answer it because he's a better answer. But let me just say this: what the Labor Department has told us, you need one of the factors that gets glossed over, and I know this mainly because Mr. Reish has made this point in my earshot more than once, is to take into consideration when you think about that best interest of participants and beneficiaries. And the Labor Department has specifically said to take in one of the factors you should be taking into account is the demographics of your workforce. Now, presumably, that's more than this one single individual, unless maybe he was at the at the forefront of a massive wave of equally aggressive individuals, kind of thing. So, again, whatever your own personal philosophies might be on these kind of things, and there's reason to have whatever, but you need to take that workforce demographics into place as well. Now, Fred, have I taken all your thunder?
No. The guidance that Nevin's referring to was, I don't know, maybe a decade ago, but years ago, the Department of Labor issued tips on selecting target date funds. Unfortunately, I mean, they do list some of the things you should consider. Unfortunately, it isn't as robust as I would like. But if I were working with that plan committee, I'd say, there are at least 2 or 3 considerations. One, as Nevin pointed out, I think the demographics of the workforce. Possibly, if you have an automatically enrolled plan with lots of people defaulting into the target date funds, you might even limit that to the demographics of the defaulted employees, because they could be more representative of the people who are in target date funds but didn't look at them before they were put into them. They just were put there. Then I think you have to look at your industry, would be number 2. For example, in the construction industry, you're going to lay off a bunch of people when we go into a recession. That just happens all the time. Any industry like that has a lot of layoffs, why would you want to put people into really aggressive investments when they're going to probably have to cash out when the market's at the bottom? Makes no sense to me at all. So that, to my mind, would be more conservative. Now, that would be BlackRock. That would be American Century. That could be JP Morgan. I mean, there are target date funds out there that are more conservative. Now, take the opposite of that. Take a law firm, and that probably very seldom lays off people. Well, you could have a more aggressive design because these are people making good money, even the staff, pretty well-paid group overall. And there's no enforced retirement age. I mean, you don't get too old to type. And that's what we're all doing nowadays. We don't have to lift anything heavy. We don't get paper cuts. So you might have a more aggressive. But and then you take yet a third scenario. You take a company that has a defined benefit plan or a cash balance plan and a 401k plan. You might look at that defined benefit or cash balance pension plan as a huge bond allocation, fixed income, and say, okay, we could be more aggressive with our target date suite. That same plan committee, though, could say, we have a relatively unsophisticated workforce when it comes to investments. We think even though we have the cash balance or pension plan, we should have a more conservative target date suite. And I don't see any judge anywhere ever saying, you plan committee really sat down and thought about your workforce, thought about your industry, thought about your other plans, and you decided this was right for them. I don't see any judge saying, no, committee, you can't decide what's right for your employees in selecting a target date fund if they go through the process. And in Intel, to pick up on where Nevin left off, in Intel actually not only went through that process, but Intel actually told their employees that we have selected a more conservative suite of target date, communicated in writing to the employees that they had gone through the process and had made that decision. Pretty hard to ever fault Intel for anything in that process. So my prediction is the same as Nevin's. I think Intel's got this case in the bag. I think it could even be a 9-0 Supreme Court ruling in their favor. So, yeah. But it's the process. Again, it's the process, Janya.
Yeah. And I mean, in that particular scenario, it actually opens up a different discussion, again, that we could have in another time, which is the committee member structure. And in this case, we had a new committee member who was the chair of the committee and was very aggressive and vocal, and he, there were committee members that were afraid to speak against him, because he was the top executive. So again, I feel like that could be an hour-long discussion about how do you handle situations like that. But I like what you're saying, Fred, about, and that's something that I think all our clients really try to do is evaluate your workforce. You made me think too about the rise of managed accounts and advisor managed accounts or record keeper managed accounts. And, one strategy you could say, if you default people to a target date fund, maybe that's more conservative. But if somebody wants to be more aggressive, then they can get that either on their own or through some other kind of managed account solution, so that and then communicate that clearly to the workforce. So anyway, sorry, just thinking in my head as I'm listening to you all.
Nevin, we probably have another 10 cases we'd like to go through, but people don't have all day to spend online with us. So maybe I'll have to have you back in the future. But you can't have an ERISA litigation program today without talking about forfeitures. So tell us something about forfeitures, Nevin.
Forfeitures, something nobody ever, I don't think, really gave a lot of thought to until a couple of lawyers in Pasadena, California, one day rolled out of bed and decided this would be something worth class action litigation. And fundamentally, and for, I don't know, probably pre-ERISA, the notion on forfeitures is there are three legitimate things to do with forfeited balances. That is to say, the balances that an individual who's not fully vested, when they terminate or leave employment, and they sort of leave that behind, then the choices are, what do you do with that money? And the choices are, you can use it to offset employer contributions, you can use it to offset expenses of the plan, or you can reallocate it among existing the participants who are still there, kind of thing. Now, of course, the caveat in all that is there's a presumption with that leave behind that if any of those individuals who left come back, you might have to restore their balances. You would restore their balances from those forfeited accounts. So that's that. And I think for a long time, people have appreciated the fact that I've got options here. I've got choices. I can do one of three things with it. And right, wrong, or indifferent, I think probably at some level, Fred, you'd have a better feel than I. The vast majority, certainly of pre-approved plan documents that are out there, provide discretion to the plan committee to do, you can do any of these things you want. Sometimes there's an order, sometimes there's not, but it basically has been left in many cases that this is something, the committee decides. And so it's like hanging out there, and people have been doing this for a long time. And I suspect in many cases, maybe most, maybe in nearly all of these cases, plan sponsors have decided to take that money and use it to reduce employer contributions for the next time. And that's what they're getting sued for. Doing something that is absolutely allowed by the IRS, allowed by the law, if you will, in terms of what you do that, certainly consistent with long-standing patterns in the industry in terms of that. But their argument has, generally speaking, been that choosing to take those forfeited balances and offsetting company contributions is not in the best interest of participants. It's in the best interest of the employer, but not in the best interest of participants. That's certainly been the argument that's been put out there. There are, and I've lost count, there was a recent case where a judge said that 51 of these cases that he had come up with had actually gotten to some level of adjudication. There have been many more than that, maybe as over 100 that have been filed. So at some level of adjudication means that a judge is actually considering a motion to dismiss on that case. But it's been a lot of them in the last couple of years that have been brought this up. And most of them, the motion to dismiss, and again, remember, you've filed suit, then the other party, the defendant in that case, would file a motion to dismiss the suit. The judge will look at that, and it basically, with some inferences, some biases towards the party who did not move to the dismissal, so to the plaintiff, They will look at the situations, accept what the facts presented by the plaintiff as accurate, and they'll make a determination as to whether a case is actually sufficient to go to the next level. So you have the filing of the suit, you have a motion to dismiss, you have a response on that. Sometimes if it's rejected, if the motion to dismiss is granted, then the plaintiff gets another chance to fix their problem and file the suit again and rinse and repeat kind of thing. 2 times, sometimes 3 times before you actually get into the discovery part of the trial. So these things have some shelf life, if you will. So there's been a lot of these suits. They're not all factually identical. There have been some where the plaintiffs have basically argued that what the employer chose to do was in conflict with the plan document. In other words, the plan document didn't allow for them to offset employer contributions, or it said you have to offset expenses first and then go into the employer contribution. So there's some of that. Most of them seem to be in a situation where the committee had some level of discretion as to how to dispose of forfeitures. And that's really kind of been the issue. The issue is that if you've got your fiduciary committee making a decision about how to reallocate forfeitures, that's a fiduciary decision. The fiduciary decision needs to be, in the best interest of participants, So that's, in 35 words or less, kind of like the current state of things.
Yeah.
What do you think, Fred?
Couple quick thoughts on that. One, I think you said, Nevin, that for the most part, employers have won the decided cases so far. A lot of them on motions to dismiss, meaning they won on the law.
Right.
There's a DOL case from several years ago where a plan document said the forfeitures we used to pay expenses, the plan sponsor had used them to offset contributions in violation of the plan document, and the Department of Labor won and the plan sponsor lost. So sort of the moral of that story is, look at your plan document, know what it says. There was a lawsuit just filed against Ford, the automobile company, where the plaintiffs alleged that the documents said that the forfeitures had to be used to pay plan expenses first, and they didn't. That's the allegation. I don't know what the Ford document actually says. But so moral number one of the story is everybody ought to look at their own plan document and see what it says. Make sure you're administering it consistently. Number two, even though employers are winning most of these cases, the issue hasn't gone away. This could potentially get all the way to the Supreme Court, like the Intel case on conservative target date funds is. And there's a case just decided, the United Health case, the big company, United Health. And to tell you, that was in favor, a motion to dismiss ruled in favor of the plaintiffs, not the plan sponsor and its fiduciaries. But to give you an idea, just to elaborate a little bit on what Nevin said, the Internal Revenue Code says forfeitures can be used to pay expenses or offset contributions or be allocated to participants. The Internal Revenue Code, which has the plan qualification rules, says that. ERISA, Title I of ERISA, which all these lawsuits are based on, says that fiduciaries have to act prudently and in the best interest of the participants. And so you have 2 laws, one of which the Internal Revenue Code is clearly would allow it. The other of which you have to say, well, what's in the best interest of the participant? Because the courts have almost uniformly ruled that the forfeitures are money in the plan, and therefore they're plan assets, therefore they're under the control of the fiduciaries. And here's what the United Health case said in ruling in favor of the plaintiffs. The fact that the committee might lawfully, meaning the Internal Revenue Code, have used forfeitures to reduce United Health's contributions does not answer whether the committee's decision to do that complied with its duty of prudence. So something could be done lawfully, but maybe not prudently, is what the court says. There's a range, a very wide range of lawful things you can do and more narrow range of prudent things. That's what that court found. I'm not saying that's where everything's going. I'm just pointing out to highlight the reason why you really need to know what your plan document says, because we're maybe in the fourth or fifth inning of this baseball game called forfeiture lawsuits. And so, yeah. And then the last thing, most of y'all listening to this have pre-approved plan documents. We're later this year going to enter what the IRS calls cycle 4 amendments, meaning all of your documents are going to be amended. All of them. Every last 401k plan out there in due course will be amended, but particularly the pre-approved plans are part of this thing called cycle 4. The IRS is taking the position that you have to specify in your cycle 4 amendment exactly how forfeitures will be used. So it's coming where that you can do this or that or this other thing, the 3 that we listed. That's not going to be the case anymore once your plan is amended. Make sure to really look at this closely when you amend your plan, because you want to decide, how that's going to be used. Are you going to allocate expenses to participants and forfeitures to offset company contributions, or something else? You have to make a conscious decision hardwired into the plan document, and you can't change it from year to year after that without amending the plan document. So it's coming. A big decision moment is coming. For the moment, though, make sure you're operating in accordance with your plan document. The highest danger, the highest risk, in my view, is a plan document that says you shall do it this way first, and you're doing it a different way first. That's the high risk area. Everything else is going to ultimately be decided by the courts, but that one, there's not a lot of wiggle room there. So,
yeah, and anyway, I was going to add on that, Fred, don't rely on your record keeper to be able to thinking that they're going to monitor it for you. They will do whatever you tell them to do. They'll direct them to use those monies for a certain thing. Not all of them, if any, have safeguards built in. They haven't hardwired that into their record keeping system. I think we will see this start to change, to your point, Fred, since with the restatements, we might be able to see better, guardrails from a record keeping perspective. But don't overly rely on your record keeper for that.
Yeah.
Now, keep in mind, these suits, they're not standalone. I mean, most of the early ones have been standalone suits. They are the Ford one that Fred mentioned, for instance, is one of what I call a kitchen sink of allegations about the plan kind of thing. They throw in the forfeitures on top of everything else. And there have been several cases of late, at least a half dozen, where this is one of the things that's been alleged, not the only thing. So to keep that in mind. Secondly, there are 4 of these cases right now that are already at the appellate court level. And on those 4 cases, and again, each one has individual fact patterns, the Labor Department has basically weighed in with a friend of the court, what's called an amicus or an amicus, I don't know, depending on which way you want to say it, brief in favor of the plan fiduciaries, backing them, if you will, in their decision to choose to use those contributions to offset employer contributions. That, again, in those situations, nobody's alleging they did anything violative of the plan document. So that's an important separation. And the Labor Department not only has filed that brief in favor, but has asked for and been granted an opportunity. They get 5 of the 15 minutes of oral arguments. The Labor Department is going to stand in and say why it thinks it's okay to have done what they did. But again, remember, these are 4 cases that have already gotten to the appellate court level. So they have already had to go through the motion to dismiss, in some cases more than once, and then going to appeal, discovery, all this kind of stuff. So it's a painful path. I think, to Fred's point, you can't have this many cases going on around this issue in different districts that you don't end up having an opportunity to be held at the Supreme Court. The PS on all this is, I believe this is the case in the United Health case that Fred was talking about. The judge is sitting there looking and he says, and I think it's a he looks at this and says, I know there are other courts out there that have ruled differently. But at the motion to dismiss stage, he was willing to sort of make allowances for the case to go on to the next level. In other words, he thought the plaintiffs there had made enough of a case to make it worth going in and getting discovery and getting a little more information kind of thing. So there is an acknowledgement that there are a lot of these cases out there and judges are ruling differently. This United Health is not the only court to support or to reject the motion to dismiss, but right now that tends to be the minority. But they're not the only ones. And recently, it's almost like judges are looking at this and saying, yeah, I know other guys have dismissed it, but I'm going to look at it a little differently here. Because this, if you think about it, if you're sitting on the outside of this and you've not been working in ERISA plans for 30 or 40 years, the notion that, you think about the best interest of participants, you got to look at it and say, well, how could using it to offset company contributions, how could that be in the best interest of participants? And you can understand, I think, why, if you step outside of things and you look at the world a little bit through a different lens, why that might be an issue, certainly an issue worth litigating. So we'll see.
I think Evan and I are just getting fully wound up, but unfortunately we've run out of time. So
yeah,
Janya, maybe we'll have to follow up on this at some point with Nevin and just talk about some of the other things that plan sponsors should be paying attention to. But I hope everybody found this valuable. And let me turn it back to you, Janya, to close down the program.
Great. Thank you, guys. This was fun. I'm sure everyone listening could tell that we could probably sit on here for a few hours and just be excited to chat about these things. We are going to have this, it is being recorded. So if anybody needs it or wants it, please reach out and let us know and we'll send you a recording. I'm also going to put together a summary of it so that if you didn't want to take notes or you couldn't take notes, we'll have some of that summarized. The Reish brief is our fiduciary training, or one of the ways we do fiduciary training. We do it a bunch of different ways, but it will happen on a quarterly basis. So if you'd like to make sure that you're invited every time, also send me a note or your advisor a note. But with that, thank you all for taking the time. Nevin and Fred are full of lots of great information. And if there's a topic that you'd like Fred to cover, we try to bring in different guests every quarter. Just, again, feel free to let us know and we can talk about it with Fred and see if that's something that we want to cover on an upcoming Reish brief. So with that, everybody, have a wonderful rest of your day.
Thank you.
Thanks, take care.